documents is private and not to be construed or relied upon as being legal advice for an individual legal situation or employed for making a legal decision. You will not use any of this information for making a legal decision or performing a legal procedure and is not a substitute for legal advice and or guidance by a licensed attorney. This private show and or documents are for academic informational purposes only to be used at your own risk without liability to Christian Walters. By accessing or reviewing this show or using the documents therein, you understand with agreement that, with all rights reserved without prejudice, Christian Walters is not an attorney licensed to practice law in the state of Florida or any other state, and has not given legal advice or accepted fees for legal advice, provided no assistance, advising, or guidance of any kind for use by non-attorneys or pro se parties in the preparation or use of herein referenced, and has no interest in any use referenced therein, and is not a party to this or any action arising from, and is only acting in an authorized capacity as liaisons to communications between the parties. By reading and or using this information, you acknowledge and agree that you are not a client of Christian Walters. These documents and or show recordings are incomplete and void without this notice agreement being attached herein by reference, and a breach of this agreement. Upon breach of this agreement, the breaching party becomes liable for admiralty commercial damages of $100 million or more per stultification or impairment per Christian Walters' discretion. Thank you for your understanding.
I'd like to welcome everyone to this Monday, February 21st edition of Money, Banking, and Trust by Moving Titles and Commerce. I'm your host, Christian Walters. Welcome to NTT as New Trust Technology. Tonight's Monday, the Monday Maxim night, and this is the Trust Ambassador call, so Eric, are you on?
Q&A session started.
Hello, good evening, Christian.
Hi, Eric.
And hopefully Marshall will be joining us in just a little while.
Okay, you're on.
I haven't heard from him in the last several hours, but usually he comes on in a little while, and if not, then I have some wonderful things I'd like to share with everyone this evening. And what we're doing is we're continuously building upon the understandings of the maxims, and the more that we build on the understandings of the maxims, the more that we can apply different foundational things as far as building on an understanding of the doctrine of NTT and how to express trust and enforce that trust. Because ultimately, all this knowledge with new trust technology is completely useless without the enforcement. And what I'd like to do is I'd like to share a couple of things that we discovered recently that are foundational, and then tie some of the maxims into them. So what I'd like to do is direct everyone to Henry Gibson's A Treatise on Suits and Chancery. And while you guys are getting that open, I'm just going to take a moment and grab a hold of this section that I'm going to be sharing in a moment while I'm waiting for you guys to get that open. And if you have the PDF, we're going to be going to page, look here, page 41 and 42 of the PDF, and that's going to be page 15 and 16 of the book. And that's going to be a treatise on suits and chancery, and that's going to be page 41 and 42 of the PDF, section 15 and 16 of the book, and this is going to be, or pages 15 and 16 of the book, and this is going to be sections 21 and 22 that we're going to be looking at to start with. And then we're going to take these equitable maxims and look at them through the frame of what we'll be sharing this evening. So I'll give everybody a moment to catch up to that, and please share your questions on the Welcome NTT group. If you're new to the call this evening, please contact Faith and then the number 2 Trust, Faith to Trust on Skype, and ask to be included in our Welcome NTT Skype chat group. And again, that's Faith to Trust and Ask Faith to Trust on Skype to be added to the Welcome NTT chat group. And again, I want to say a big thank you to all the people that are working to transcribe these calls. And if you're new to the whole NTT group, then please ask to become a transcriber, because it is the best way to learn NTT is to go through the past calls and learn through the breaking down of each and every word and each and every concept of the call, because it'll force you to go into your Black's Law Dictionary and into Henry Gibson's book and read his stuff and all the stuff that we've talked about over the course of time. and it'll cause you to listen to these recordings over and over. So that's how I learned. This is how I got this to this level of knowledge. And I'll be the first to say that I have a long way to go, but day by day, by the grace of God, I'm learning, and I hope that you guys stay with it. And by the grace of God, you learn as well. And so again, for everybody that's up to speed with where we're at, this is page 41 and 42 of the PDF of Henry Gibson's The Treatise on Suits and Chancery. And if you don't have that book, please ask for the link in the Welcome NTT chat group in order to get that book, and that way you can follow along. So what I'm going to do is I'm going to begin reading 21, and then I'm going to read 22 to lead into the foundational concept that's so important to everything we're doing here at NTT. So the effect of the Act of 1877 generally considered in Section 21. In 1801, it was enacted that after an answer filed and no plea and abatement to the local jurisdiction of the court, no exceptions for wanted jurisdiction shall ever afterwards be made. So the reason I want to point this out is because if you've been listening to the past two Monday night calls, we've played, first I actually read live on the call the Section 71 waiver, and then we played it again because it's that important to know that if you don't express a want of jurisdiction, then you waive it. And that's so important right here in the very first sentence of 21, all the things that we're waiving from the moment that we get a summons or a subpoena, depending on whether it's a action or a suit, action at law or suit in equity. We need to know what we're waiving and what we're giving up. So as I read this, realize what we can exercise for our own well-being, for the outcome of our agenda, for our suits, or what we're waiving to allow the other side, and keyword allow the other side to go ahead and hold us as trustee and liable for the debt. So as I'm reading this, look at this stuff through that set of eyes as to what we're letting them or allowing them to do, or what we're expressing and not waiving. Continuing on in the read in Section 21 is it has been uniformly held ever since the passage of this act that on failure of the defendant to object to the jurisdiction of the court before answering, the court had the right, and it was its duty to determine the controversy unless the matter was unfit for a court of equity. So realize that when we fail to repudiate their repudiation, then it's the court's right and its duty to determine the controversy. And what they mean, what Henry Gibson means by that, is by the jurisdiction of the controversy, unless, of course, the matter was unfit for a court of equity. Reading on, under the operation of this holding, the Chancery Court had, for 75 years, been in the habit of entertaining demands and causes of actions purely legal in their nature, while the Act of 1877 is only one step further than the law was before. As Judge Freeman in Jackson v. Nimmo very conclusively shows, the Chancery Court has long had jurisdiction in attachment cases of debtor demands of a purely legal nature, except causes of action founded on torts. Thus, it will be seen the Act of 1877 is by no means as revolutionary as was at first supposed. Every enlargement of the Chancery jurisdiction for 500 years in England and America has been the signal for an alarm, but the enlargements have continued until, both in England and a majority of the American states, the Chancery methods of pleading and the principles of the Chancery jurisprudence have, in large measure, superseded the unbending formalities and harsh doctrine of the common law. The Act of 1877 goes far to settle the ancient controversy between the Chancery and the common law courts with respect to the boundary line between their respective jurisdictions, and it includes only the disputed territory. Reading that again, and it includes not only the disputed territory, but also the territory adjacent thereto, within the concurrent jurisdiction of the Chancery Court. So that right there says that the legal and the Chancery, or the equity, can run concurrently. Reading on, in the English Judicature Act, passed in 1873, it is provided that generally, in all matters in which there is any conflict or variance between the rules of equity and the rules of common law with passion is to make the rules of equity supreme in all litigation, in all the courts of England. And just so you know, everyone, the courts here in America are nothing but a future manifestation of the courts of England. This is the model for our courts today, is the courts of England. So make no mistake, everything that was foundational in England exists today in our courts. Reading on in the text, it is believed the Tennessee Act of 1877 has the same effect in all common law rights of actions sought to be enforced in Chancery. When the jurisdiction of a court is enlarged, the new subjects of jurisdiction should not be treated as aliens and discriminated against, nor should the parties of suits be held in disfavor or denied any equitable right, benefit, or privilege accorded by the court in the ordinary exercise of its jurisdiction. The Act of 1877 was manifestly intended to enlarge the jurisdiction of the Chancery Court as a court of equity, and not to make it, as to this enlargement, a mere common law court. And hence, in all suits brought under the Act of 1877, the pleadings, practice, and principles of equity jurisprudence will control. And footnote 52, I want to read that right here. Down below, it says, the Chancery Court in Tennessee is now equipped with full power to do complete and speedy justice in all suits within its jurisdiction. However numerous the parties or complicated their rights and duties, it is vested with authority to so shape and mold, either by law or equity, and to adjust all matters of controversy, legal as well as equitable, so as to give each party his exact rights, and to require each party his exact duties, whether such party be complainant or defendant, and whether the obligations be between complainants and defendants, or between co-complainants, or between co-defendants. And it has been clothed with unlimited power to use any kind of process, legal or equitable, to enforce its orders and decrees. And if an emergency should arise, necessitating a process not hitherto used, not previously used, the court would, when absolutely necessary to prevent a failure of substantial justice, so modify one of the customary legal or equitable processes to adapt it to the exigencies of the emergency. The Act of 1877 is liberally construed, Simmons v. Leonard, 5 Pick 622. So that footnote just goes to show how powerful the Court of Equity really is, and it can adjust and it can mold its practices to for the exact rights of the exact rights. Let me go back and look at that again. The act to mold itself to enforce the exact rights and to impose the duties on those who have duty. So as I read through this, just think about how powerful the doctrine of NTT is when we understand how to express our rights in a bill in equity, how to express our rights in a bill in equity, and to understand what is about to come in Section 22. This is so important and foundational when we look at the maxims, and I'll incorporate some of those in here in just a few minutes. But first, I want to lay this concept down. So when we look at the maxims and how logically this book's put together, the maxims are to follow these sections. And when they do, Henry Gibson did such a great job when you look at this book of how he laid everything out. First, he talked about the act that gave Chancery Court the power that it did. And now we're about to talk about the equitable jurisdiction and the statutory jurisdiction and the true difference between the two, and how this clears up so much, and how the equitable maxims apply to this, where we're going next. So Section 22, classification of matters of equitable jurisdiction. The importance formally attached to a proper classification of subjects of equity jurisdiction no longer exists in this state, and it is now immaterial whether the matter is in controversy is within the equitable or the statutory jurisdiction of the court. And if within the equitable, it is unimportant whether the jurisdiction be exclusive or concurrent. As a result, all the abstruse learning in the books on the lines of demarcation between the different grounds of jurisdiction has ceased to be of much practical value. The legal niceties, the complex technicalities, and the dialectical discriminations on the subject of jurisdiction with which the great jurists of England and America wrestled in the wrestled with in the last 5 centuries no longer perplex either the student or the practitioner in this state. For convenience of consideration, the jurisdiction of our chancery courts, as now constituted, may be divided into 1, the equitable or inherent, and 2, the statutory. Number 1, the equitable or inherent, to include all those matters, whether purely equitable in their nature or having characteristics both equitable and legal. Jurisdiction which is derived exclusively or chiefly from their inherent powers of courts of equity, and 2, the statutory, to include all those matters, whether equitable in their character or purely legal in their nature, jurisdiction over which is derived exclusively or chiefly from our statutes. Just going to give you guys a moment to marinate on whatever that means, and then I'm going to go into it and explain a few things. Read that again, everyone. The equitable or inherent. An inheritance. Who did we inherit the equitable jurisdiction from? How did it become purely equitable by nature? How does something become legal by nature? And equitable meaning special equity, and legal meaning at law or statutory. How do things become one or the other? Well, if we'll refer back to the recording from 9:4, when Christian talked about limitations of action, and for those of you who are new, who haven't heard the recording, please contact Faith to Trust for the link where you can download it. And for those of you who've been with us a while, go back and listen to it again. And listen to it in this context of what 1 and 2 under 22 says. When we walk in the door and we fail to express our relation and the nature of the relation, it defaults to the commercial relationship, the purely legal in nature, which is what we're all used to walking in the court and observing either ourselves or others who go to court. Since 1989 for the Maxey Center versus Hutchins case here in Florida, it's been that way. And only about 100 cases over the last 75 years or so, or 75 cases over the last 100 years, but very few relatively. What we're used to seeing is the purely legal nature. And what we're doing here at NTT is we're talking about the purely equitable nature and the difference between the two, and defining the nature of the relation of an equitable nature and character instead of a legal nature with an equitable character, because that's what they're doing. That's what statutory equity is, a legal nature with equitable character. But here at NTT, we do equitable nature with equitable character. So there's no commingling. So when we take the maxims and we apply it to these, he who seeks equity must be doing equity. Well, if we're going to come in and we're going to put that maxim to task, then we got to come in as in with a claim of an equitable nature and evidence to back up that claim of an equitable nature. Because if we fail to come in and do that, then we can't use that maxim. We can't use it as our proof because we all know that the maxims are the proof. They are the rule, and that's how we move the court, by rule. So if we choose the at-law side, the fictional side, the side where they can't see the real man, by choosing a purely legal nature, we're not doing equity. And if we're not doing equity, we can't be seeking it. And we can't be vigilant. And equity will not delight in doing justice, and not by halves. And I'm trying to think about some of the other maxims, which I'm sure we can apply to these two foundational concepts here. I'm going to go into the maxims now just to look at how all those maxims apply towards this. So if you guys want to advance over to the maxims section of the book and understand foundationally how important it is, and equity acts upon the person. Well, that's page 52 of the PDF. Well, if equity acts on the person and we're doing things of an equitable nature, which is inherent, we can't use that maxim. It doesn't apply to us if things are of a legal nature because they're of a fictional nature, so equity can't act on the person. It's just, it's apples and oranges. It's two different things. Going on to the next maxim in section 33 on page 53 of the book, equity will not suffer a wrong to be without a remedy. Well, considering that things are so misconstrued on the outlaw side, and the judge can do whatever he wants up there on the bench with immunity, how can that maxim ever apply? doing equity if you're not coming in with a purely equitable nature. Because what we feel is done wrong to the person, to us, we can never say a word about. We can't apply that maxim if we don't come in purely with an equitable nature. Section 34, equity acts specifically and not by way of compensation. So in order to get our specific performance and not damages, but to get that trustee to act, to extinguish that debt, if we don't come in purely of an equitable nature, then we can't get equity act specifically. The only thing we're going to get is the at-law damages, add more debt to the national ledger. And all that does is further enslave our brothers, and that's not fair. That's not equitable. 35, when parties are disabled to act, the Chancery Court will act for them. Well, if you don't come in with a purely equitable nature, your claim is not purely equitable, the at-law court is not going to act for you because they can't see you. The only thing they can see is your fiction. Well, you know what? They might act for you all right, but it's not going to be to your pleasing. I'll promise you that. They're going to put you in the warehouse and arrest you. They're going to arrest you from doing commerce because they're going to take your straw man or your title, your liability title, and they're going to put it to work on Wall Street, and they're going to act for you. But that's not going to serve you, the real man or woman, very well. 36, page 56 of the PDF. When Chancery has jurisdiction for one purpose, it will take jurisdiction for all purposes. If we don't go in under a purely equitable nature, we can't rely on the fact that Chancery is going to take jurisdiction for all purposes based on one. So right then, we're going to be right back at the outlaw side. The nature of our claim and the nature of our evidence is foundational to all these maxims being the proof, the evidence for the equity court to act on our behalf, for the real man. Section 37, the Chancery Court never loses its jurisdiction by implication. So in order for the Chancery Court to retain jurisdiction, to make the orders on behalf of the grantor, we have to make a purely equitable claim. 38, equity delights to do complete justice and not by halves. I discussed that one a few minutes ago. We can't utilize that one unless that claim is purely equitable in nature. He who seeks equity must do equity. I started out with that. Section 40, page 59 of the PDF. Courts of equity will not tolerate any intolerance with their officers, process, or decrees by the courts of law. Everybody's always crying, that judge screwed me over. They didn't listen to me. They didn't even hear what I had to say. Boo-hoo. Well, if we want a court of equity to listen to us, so it won't tolerate any interference with their officers, process, or decrees by the courts of law, we got to make our claim purely of an equitable nature. And then we can stop crying that all these courts are just rolling over us and we're not getting our way. Well, it's impossible to get our way if we don't have a claim and evidence that's of equitable nature and character. And when I say equitable, I mean special. Moving on to Section 42 on page 62 of the PDF, he who comes into equity must come with clean hands. They're never going to see our clean hands unless we have the claim and the evidence to back them up. And yes, we have a duty to make records to make sure that we show that the other party's hands are dirty. And that's where the administrative process through a notary comes in to default the other party, where they can see it in the private, because they can't see our private process in the public. Even though the notary is a court officer, an officer of the court, they're not going to look at that as something that we can utilize in the outlaw side of the court, because of course we're fictional, and anything we do as real men, they're not able to see. That's why they have to call you by your last name. That's why you go to court, they very rarely or never call you by your first name, because they got to address the title for the record, because otherwise if they called you by your first name, the record would never see you, because the outlaw side doesn't see you as a real person. They only see you as a title or a fiction. 43 is really foundational to the nature, because it says equity looks to the intent rather than to the form. Well, in the outlaw side, they can't see intent. They can only see form. They can only see the violation. They can't see the intent of the real man. And intent comes from a natural being, from you, the real man. So in order to apply these maxims, you got to show that there's a equitable or real nature here, a nature that shows that there's a substance to it, not a fiction to it. And 44, equity imputes the intention to fulfill an obligation. And it goes back to intent. When we go to nature, and we know that equity is going to impute means puts the duty onto an intent to fill an obligation. Equity is going to figure that if that trustee had a duty and they had a duty to fulfill it, if you come in with a claim and evidence that's of equitable nature, they're going to be able to see that that trustee, that real man, had a duty. And they're going to impute it upon that real man, your intent to put that duty on that real man. But again, if we fail to make that claim with that equitable nature with the evidence to back it up, then we waive it, referring back to Section 71. Section 45, equity regards that is done which ought to be done. Well, how can equity ever look at the trustee as having already done the duty if we don't come in with the nature of an equitable claim that we have the right to take, the right, if we don't express that nature, purely equitable. And then if we do have both equitable and legal title, well, those with equal equities, the one with the equitable title and the legal title is going to win out over the one with just the equitable title. So if we have the evidence to prove both of them even, because we can have both titles possible. And that's going to show because there may be more than one trustee or more than one beneficiary, and one of those beneficiaries with the equitable title might have the duty as well as the right to take. So equity regards that as done which ought to be done can only be enforced, can only be looked at as the proof when we have the nature to back it up. This idea of nature, whether it be legal or equitable, is just as foundational to everything we're doing as these maxims. And 46, which is page 66 of the PDF, no person bound to act for another in any matter can, as that matter act for himself. Well, the key word in that maxim is person. And some people might say, well, person could be a corporation or some other entity beside a man that's a sentient being. Well, in the doctrine of NTT, when we're saying nature, we're talking about natural. We're talking about the natural man, not the fictional corporate person. And that's the realm we need to keep this context within. So if we are imputing duty upon a trustee, that trustee can't act for another. He's got to act for himself. And even though it says this, while not a maxim, it's a foundational doctrine of equity, as one fruitful of many most beneficent consequences. In the first place, whoever undertakes the act for another's benefit impliedly contracts that in every matter affecting the other he will do for him all that good reason and good conscience require. So, excuse me, I perhaps misspoke a minute ago, that if a trustee takes on a duty and somebody decides to take on that duty for that trustee based on this text here, that they have a duty to act just as that trustee's duty did. They don't have an opportunity to repudiate any of the duties that they had, that trustee originally had to do. So when we take that from the frame of, for example, a bank CEO, and he puts the duties upon some of the employees of that bank, that those duties of those employees of that bank have just as much duty as that bank CEO. And when we make an equitable claim, if the bank CEO says, well, the duty's on this person, well, then we can call that person to task and make sure that they do exactly what they were supposed to do and take that equitable title and apply it to that legal title and extinguish that debt. And they have every duty to do it. 47, page 67, equity delights in equality. This maxim is sometimes more strongly expressed, thus equity is equality, or equality is equity, excuse me. The common law delighted in preferences. It was the law of a people fond of distinctions in personal rank, in social position, in form of procedure, in evidence of debt, and in forms of actions. But the Chancery Court, early in its history, endeavored to break down these distinctions insofar as property was concerned. Joint obligations were made several, liens were apportioned, contribution was enforced among co-contractors. Co-sureties and co-legatees and the estate of debtors were divided ratably among their creditors. These changes in the common law, thus enforced originally in equity, have long since by statute or otherwise become a part of the general law of the land. In accordance with this equitable maxim, a court of chancery will divide a common fund equally between those entitled, and the fund is not sufficient to pay all in full. A prorated distribution will be ordered. In order to put that maxim to task, looking at making a claim, having a claim and the evidence of a purely equitable nature, in order for things to be equally distributed, if we have the higher claim, we can obviously make sure that things are done equally or with equality, And if there's another party, well, then they deserve just as much of the res as we might as individuals do if they have a right to take it. But nevertheless, it can't even be done equally if we don't have a purely equitable nature claim. Section 48 equity will undo what fraud has done. So we all know what fraud is. It's lying. It's deceit. And in order for equity to act on that, if we don't have that claim that's of an equitable nature, we can't get that trustee held accountable, that individual person held accountable in a special court of equity if we don't understand the nature of our claim. We might have to rely to the statutes in order to prosecute the trustee for failing to do their duty when we could utilize a court of equity by setting up our records and our evidence properly to begin with. 49, equity aids the vigilant and not those who sleep on their rights. Well, unless we have a claim that's of a equitable nature and character, how can we ever claim our inherent rights? How can equity ever aid us when we're vigilant? As vigilant as we are, if we're not vigilant about making a purely equitable a claim of an equitable nature, well, then we've left it all on the table. We failed to do equity. That's how foundational this concept in 22, I think it's section 22, number 1 and 2 under 22 is, that equity can't come to our aid unless we make the right kind of claim and understand the difference between the at-law side of the court and the equitable side of the court, and to watch things change right in front of our eyes when the nature of our claim is properly stated. I'm going to skip 50 because it's a law maxim. 51, no one can take advantage of his own wrong. And in nature, how could if you looked at it as a plant that failed to reach up for the sunlight, then decided later that it wanted sunlight, but it was too wimpy to reach up there, it would just die. So in nature, there's no way possible to take advantage of our own wrong. And that's the conscience of equity. And by making a purely equitable claim in its natural form and in its character form, then we can make sure that we can use this maxim to make sure a trustee can't take advantage of his own wrong. 52, where one of two persons must suffer loss, he should suffer whose act or neglect occasioned the loss. And imagine if we were to go to court on the outlaw side, and we failed to bring the records to show a claim of equitable nature. So fairness, where we could show that equity is equality. So we couldn't get fairness in that case there because things weren't being treated equally, and the person's neglect that occasioned the loss, that person didn't suffer. People would say, oh, that's a miscarriage of justice. Well, justice, true justice, full and complete justice is only possible through going through a special court of equity. Because when we don't go through a special court of equity, we leave half of the justice that's available to us right on the table. How is it possible to even have justice if we don't apply natural principles? And we only apply the principles that affect a fiction, the straw man, the all capital letter name, the term that the product that the term capitis diminutio applies to, which means to diminish a man's status by capitalizing his name. Look that up in Black's Law Dictionary. That's your straw man title. And that's since Roman times they've been doing that. 53, equity follows the law. We're on page 71 of the PDF, section 53. Let's see how a purely equitable claim and evidence in its nature, how this maxim applies. Let's read into it a little bit. Equity follows the law in the following particulars. 1, in adjudicating questions affecting legal estates, rights, interests, or duties. Equity applies those rules of law the circuit courts would apply in like cases. 2, in adjudicating questions affecting equitable estates, rights, interests, or duties. Equity will follow the analogies of the law where any analogy clearly exists, especially the law in reference to the descent and distribution of estates and the husband's right to his wife's chattels, but subject to her equity. So when we think law, that equity follows the law, we're probably thinking normally statutes. But law all originated from the maxims. So for equity to follow the maxims makes logical sense. So in order for us to get equity to follow all of these maxims, we've got to make the claim that's of the right kind of nature. 54, where there is equal equity, the law must prevail. And that goes back to the one with both the equitable title and the legal title, the one with both the legal and the equitable title, because the one with the legal title is going to have possession. Well, that's where the law must prevail. And in order to get where there is equal equities, the law must prevail, that maxim to apply, you got to make the right type of claim and evidence. Right back to number one, with our inherent claim, our natural claim, our equitable claim. That was our birthright. 55, where there are equal equities, the first in order of time shall prevail. Same thing. If we go to the outlaw side of the court, they don't look at what comes first. They look at who's got the better lawyer, who's going to make the better claim in court, and that might be completely without any evidence. It's all about who can make a better claim. But if we understand how important the nature of our claim is, then we're going to have the evidence to back it up, and no matter how much that lawyer can talk, how much fancy, flashy stuff he's going to be able to argue in front of the court, if he doesn't have evidence to back it up, our equitable claim, our claim that's of purely an equitable nature and equitable character, that lawyer doesn't have a chance against. First of all, because once we stick to the four corners of our pleading, that lawyer's not going to have anything to come back with anyways, because he's not going to have anything in this pleading that's going to address the issue. Because once we're the grantor and we put the liability on the other side, that lawyer could try to talk all he wants, but that trustee still has to do that duty. They still got to apply that equitable title to that debt title and extinguish that debt at the end of the day. Section 57, equity regards the beneficiary as the real owner. Keyword real. So when we go back to our claim that's of an equitable nature, nature means real. And we're going to make that claim because we have the right, and we have the right because we're the beneficiary. So this maxim applies perfectly in line with that concept. 58, equity enforces what good reason and good conscience require. Well, that claim and evidence of an equitable nature brings that maxim perfectly into play, because now we have good conscience. We have conscience that gets applied to the situation, because the real person is making the claim, and to a real person that the equity court can clearly see, they apply conscience and good reason. Not just the harsh, big, swiping, sharp sword of the statute to just come through and cut everything in its path without any regard for consciousness. So it's so foundationally important to understand that our claim must be of an equitable nature for equity to enforce what good reason and good conscience require. And 59, I'm not going to read the Latin, I'm going to read the English translation on page 75 of the PDF. Adhere to the decisions and do not unsettle, question, but arrest. If we just think about what that means as far as the power of equity to settle a matter, and the claim and the evidence that we bring, and the other side when they fail to bring their claim and evidence, because once we have it, what claim and evidence are they going to say if they fail to do the duty? Because the equity court looks at them by default that they're guilty before they ever come to court, just like they do with us when we fail to repudiate the repudiation. I'm going to read in this maxim a little bit just to give us a little bit better understanding. It is more important to a people to have their laws known and fixed than to have them precisely just. For our conceptions of justice differ, but what is fixed is certain, and what can be conformed to. The decision of our courts are like signboards whereby we shape our course and keep on our road of safety. The law must run straight lines and cannot be crooked to suit supposed exceptions. Fluctuations of judicial decisions have an effect similar to the shifting of the magnetic needle. No one is sure that he is traveling in the right direction, and no one can give safe counsel. Hence, it is that courts deem a decision which has become a rule of property as binding on them as legislative enactment. I just had a question. I'm reading from page 75 of the PDF, section 59. Page 75 of the PDF, section 59. Hence, it is that courts deem a decision which has become a rule of property as binding on them as a legislative enactment. And this is so whether the decision was originally correct or not, or whether it affects property or a point of practice. Laws are made for the greatest good of the greatest number and must necessarily be general. It is better that the individual conforms to the law than the law conform to the individual, and it is better that a particular case of hardship be unredressed than that law be violated, when the violation would occasion much mischief, and that especially would unsettle the foundation of property rights and disturb the landmarks of the law. But the rule of stare decisis is not so inflexible when the decision is recent that it has not been given satisfaction. So I'm trying to look at this and apply this under the idea of the equitable nature and seeing if it really does apply. I think this is more of a principle of equity than a maxim. And really what I want to look at this as is through the eyes of maxim and applying the nature of equity and the character of equity towards making our claims and evidence. So in evaluating this one, while it is important to understand that once we get a decree from a court of equity, we can use this principle to leave that decision or that decree at rest. And that might be where this applies, but I don't think it applies going in order to be something foundationally we can use to express the importance of the nature of our claim being equitable and the character of our claim being equitable as well. And then number 60 on page 76 of the PDF, no one should be condemned without a chance to be heard. This is a fundamental maxim of equity jurisdiction and always been sacredly observed. Well, if indeed it is a principle founded in natural justice and of universal application that no man be proceeded against in a court without notice. The inherent love of fair play contained in the maxim has always and everywhere been recognized by all judges and courts, and the practice of all tribunals is to render judgment against no one without giving him a chance to be heard on his own behalf. Him a chance to be heard on his own behalf. Well, we can only speak and be heard on our own behalf if we make a claim that's of equitable nature and of character. So once we're heard, the court can see what it is that they need to make their order on. So in looking at all these maxims, and I think that's that's the end of the maxims, and looking at them as to how they apply to, I believe it's section 22. Let me go back and make sure I got that right under number 1 and number 2. Now we can start to see how important it is to apply these principles of nature and character and them being equitable instead of statutory, and what we actually waive if we fail to do that. And tying all the maxims in and connecting all the dots here, it's so important to understand that our nature needs to be equitable. And the other thing that I want to point out is in section 25, which is page 44 of the PDF, the equitable or inherent jurisdiction specially stated, and also point out in that title of it being inherent. The equitable or inherent jurisdiction of the Chancery Court includes all cases of an equitable nature where the debt or demand exceeds $50. These cases include the following, and I'm going to go straight to 3 and 4. All suits resulting from trust, express, constructive, and resulting. 4. All suits for specific performance of contracts. And we can also say contracts also meaning indentures. So right there includes all cases of an equitable nature. So this concludes what I wanted to share out of Henry Gibson's book this evening, and I'd like to go ahead and ask our call moderator to open it up for questions and answers. If anybody has any, please press *6 and then 1 to get in the queue to state your name and where you're from. Again, *6, then 1 to state your name and where you're from, and please come on and let's discuss what we talked about this evening. Again, *6, then 1. we're opening it up for questions and answers. *6, then 1. State your name and where you're from. I'll give this a moment, and I'll find out if there's anything else that I feel is foundational to share. And if not, then we'll be ending the call soon. So again, *6, then 1 for anybody that would like to join us for the call to see if there's anything that you would like to discuss about what we talked about, the equitable nature and expressing that, being that in order to express trust, it needs to be specially stated. All right, well, if no one has any questions or anything to share about what we read tonight, I hope everybody had a chance to learn something about putting their bills in equity together. And we have a call tomorrow night at 10 o'clock, and the call-in number is 712-432-0075, and the PIN code is 149939 for anybody that might hear this recording in the future. And go over those sections, read them, figure out how it applies, and when you're putting together your bills in equity, hopefully you'll be able to understand that the foundational ideas of stating our nature properly, being equitable in our character of our bill, being equitable, both of those in order to invoke the things that we're trying to invoke, that we won't leave that we won't waive that. Actually, it looks like we have a couple of people that would like to come on the call and discuss some things. Dan, are you with me?
Yes, sir, I am. Can you hear me okay?
Yeah, I can hear you fine. Good evening, Dan.
Hey, bud. Hey, I know that you were going over basically maxims tonight, but you were also mentioning bills and equity, and that's exactly where I'm at right now, is working on bill and equity. So that's what my questions are going to revolve around tonight. Is that okay?
Yeah, absolutely. And when we're revolving your questions around the bill, let's incorporate the foundational thing that I discussed tonight about the nature of the way you're approaching your bill.
Yes, exactly. Check. All right, so basically...
And remember, keep it hypothetical for the call, my friends.
Right. Basically, I was hypothetically thinking about working off of Section 154 for present form of an original bill.
Hey, Dan, what page of the PDF is that so everybody can get there with us?
Page 167.
Thank you.
No problem.
All right, and Section 154, present form of original bill. Okay.
Yeah, so I'm kind of toying around with drafting a bill off of this example right here. Now, until I find my rules for my state, I'm just kind of throwing it together off of a separate pleading, but adding an at-law pleading, but adding the proper equity terms in here. And so, since I don't have a exact judge, I figured a judge in equity that I know of here, I figured I'd just address it to an honorable judge in equity instead of, Honorable John P. Smith that we see right here under Section 1, the address. I figured I'd just put a judge in equity.
I have an idea for you.
Okay. Let me get my. Go ahead.
All right. Here in Florida, when I looked up did some research about special masters, because if you'll look in Gibbs' book here, he'll talk about that there's masters in equity.
Okay.
Well, when I did some research in Florida, I found that they've changed the term masters to magistrates. Okay? So perhaps if you were to do some research in your state, you could find out what the Supreme Court has terms these masters in equity, whether they term them special masters or magistrates.
Okay.
And that might give you the proper terminology for the proper address of your bill.
Very well. Very good. I will do that.
So does that answer your first question? Because I can't answer exactly on how to address, because it's going to be determined by the Supreme Court in your state.
Yes. Yeah, that gives me somewhere to go.
All right.
So moving along, now the commencement or caption, I basically styled mine exactly like that, except for instead of putting complainant, I put grantor, settler, and then complainant after I state that I'm a resident of my county.
But let's make sure we clarify something here. Before you get your declaratory relief for a determination of trust,
right,
you're not going to be concerned about a special master. You're still going to be dealing with the judge, so the judge can see the evidence, which is, I believe, page I of Gilbert's summary, Gilbert's law summaries on trust. I believe that's page I, and if I'm wrong, please correct me. But you're going to have to make sure that that evidence that you present to the judge, passes the trust test. So this bill that you turn in is going to be addressed to the judge for them to make that, to give you declaratory relief for that a trust exists.
Well, that's going to be no problem.
But I'm just saying, in order to, when we're talking about the address of who you're addressing to make sure we draw the distinction between whether it's a judge to begin with or a special master to begin with. These are two different folks.
Okay, gotcha.
Okay.
Okay.
And I needed to clarify that just in case I didn't make that clear earlier, and if I didn't, I apologize.
Oh, you're okay.
All right.
I'm actually looking through the eye right now as you're talking, just to make sure that you're not lying. I'm sure you're right. I'm sure I've seen it before.
Well, it's been a while since I looked at it, and I think it's page I. If not, it's pretty close right around there.
Page I. Tonight's nature of relationship. Where was that at? Because this is under the Gilbert exam strategy. Page I.
Like I said, it's been a while, so I'll tell you what, if you want to do a little bit of research on that and maybe come back on the call in a few minutes after, if we bring somebody else on, looks like somebody else is in the queue, we can further discuss some of your other questions.
Well, how about I just worry about that later and move right along here. Okay, so now this is where I'm going to get I'm going to get extremely hypothetical, okay?
Yeah, of course.
Now, if I was to come over here in the statement of facts, the very first statement of facts maybe go along the lines of that there's been, fraudulent conveyance, fraudulent concealment. Speaking of the debtor-creditor contract, is fraudulently concealing the trust, a definite breach of trust, and then namely the two trustees, and go on to complain that they're still holding legal title and are in possession of the trust res, the specially deposited trust res. They're falling down on their duties. You think that would be a good statement of facts? Since I can do it.
Well, first of all, what's your evidence that there's been a breach? What's your evidence that there's been fraud? How are you going to prove that stuff?
Well, I'm going to have to get, I guess, I'm going to have to be able to prove, I'm going to have to bring my records forward, but I can't do it in the public. I'm going to have to ask for a private hearing to be able to bring the records forward to prove, which would also obviously prove trust at that point in time as well.
But wait a minute, let's do this first. Let's make sure we put the horse before the cart here. First, what you got to focus on is you got to focus on getting that court to see the trust.
Right, check.
Okay? That's your first thing. You just need to focus on making a prima facie case with an affidavit and getting that judge to see the trust. You don't got to bring all that proof in the public. All you got to do is get that declaratory relief. Have you hypothetically focused on that first?
Honestly, I was under the understanding that the first thing I want to do is, because there's absolutely no actions at all whatsoever right now. So I was thinking that if I bring the bill in, and I can't bring the bill in unless there's a statement of facts to actually bring the charges forward. I've got to be able to show that there is trust here. Honestly, Eric, I don't know where to start.
Okay, well, wait a minute. I think I know what you're getting at. Because there's nothing pending, what you're saying is I got to figure out what I could go ahead and show to bring a bill forward. Because they haven't filed anything against you.
Right, absolutely nothing. I'm going to be the one bringing it.
Or they haven't hypothetically filed against you. Forgive me. What would be the so in your bill you would have two counts: one for claiming and proving trust, and the second for the breach because they failed to do the duty.
That's it.
What else do you need?
True. Yeah. Because after that, then we can move on. Then it'll be a non-original bill. Faith says a memorandum in trust.
Well, that would be to support your counts. But if you're trying to figure out where to start, you got to start with getting the court to see the trust, which would be one count for claiming and proving, and the second would be for their failure of the duty, which would be the breach. So now you got kind of a basic model, and now that you have a basic model, now you can start looking at these models that Gibson has shared with us so graciously as to what would actually apply to that.
All right. Looks like I can go back to the drawing board here.
Well, you had to start somewhere, right?
Yeah.
Don't be discouraged. Don't be discouraged. this is a bear. We're just waking up. That's been sleeping for a long time. He don't wake up easy, and he don't wake up fast.
Right.
But boy, he's sure gonna wake up hungry.
Yes, sir.
All right, what else you want to know, Dan?
When putting a bill in equity, and I see over here a prayer for relief. Are we going to want to put in a prayer? I don't pray to courts.
Darn right you don't, because we're a grantor. It's our law form. We demand.
Okay.
We're the creator. How do we create to something lesser? I mean, how do we pray to something lesser? We demand that serve its service.
Okay, so it's just a simple, just giving orders.
Yes.
Rather than asking, we're just ordering.
Right. Demand or command.
Okay, gotcha. Check. And would it be wise to stick maxims in the equity or in the bill?
Is it wise to stick maxims in the bill?
Yeah. Would you suggest that?
Well, you move the court by rule, and maxims are rules. So,
Okay.
are you going to? Do you need to move the court with your claim? Do you need to move the court with your evidence, or is your claim and evidence enough to make your case? And then, at a later time, for example, when you would do a hearing, would you perhaps even need the maxim unless the other party came and tried to fight it, and then you could use the maxims at that point? Why don't you do it based on his models, and then figure out if you need to incorporate the maxims at that point after you find a model that works for you? Because he states everything here so simply, so purely. If we could keep it short and sweet and we can make our case, then if it so turns out that we still need to add that in, then we'll look at that point. But once you find the bill that works for you, there might be some reference to a maxim in there that might work.
Okay. All right.
But until you have a framework, I can't, if we were looking at one and figure out where maybe we could insert it, it's hard to say.
All right. You know how I feel right now? Right now, I feel the exact same way when I did when I first learned the trust stuff. That, I know I'm about to crest and start in my knowledge. I'm about to crest and go over it, and just the whole realm of understanding is going to open up. But you know how you get frustrated at that point, because that's where I'm at. So that's why my questions may seem a little redundant or a little goofy, because I'm right at that point.
Well, you know what, Dan, you're going to find? Just like I do. Every day I open a book and I learn something else, then I find out how much I didn't know. And it keeps happening every day. I keep learning this stuff.
Yeah, I know the feeling.
Okay, so you know what? Just accept, along with everybody else, that the amount of knowledge that we learn is just another seed, another grain of sand on the beach to make that beach that's as long as the continent. Okay? And each and every one of those grains are foundational to make that beach. But just because we added another and we think that now we have all this understanding, well, guess what? We still got another 2,000 miles of coastline to go. And it seems like it's a lot, but my friend, don't let it bother you, because you need every one of those grains to build that rock.
Good analogy, man.
That foundation. So I still learn things all the time that I know are so important to creating these bills, to claiming and proving trust, and moving that trustee to extinguish that debt. So keep your chin up. I have to say the same thing to myself. Wow, I just learned another thing that, I wish I would have known from the first day. And it seems so foundational that I should have known it from the first day. Christians the same way. We're all learning. All we can do is pray for the knowledge to come to us and for the awareness to be there when it gets here.
Very well. Sounds good.
All right, what else you got, Dan?
That's it for now, man, until I dive into this deeper. So.
Well, why don't you do this? It looks like I have somebody else in the queue. Take a look at Gilbert's page I, and want you to flip through Gibson's a little bit and figure out if there's another bill that we can discuss here in a few minutes that might work for your application.
All right, sounds good.
Because it's probably right around there of an original bill. It's probably within a few pages.
Yes.
All right.
All right, I'll look.
All right, Dan. Thanks for coming on.
Thank you, man.
All right. State your name and where you're from, and then for anybody else who's listening, *6 then 1 to come on the call. Who's next? Hello. Who's next?
Hi, my name is Printa. I'm from New York.
Hi, Printa.
Hi, how are you?
Good evening.
Good evening. I had a couple questions. My husband is really into your trust a lot. I'm a bit skeptical, but he's trying to teach me quite a bit. So I'm trying to learn everything as I listen to your calls, and they're very interesting. My question is he's going through a child support case right now that's a bit difficult. And I want him to get a amendment for his child support because they're pulling too much out. And he thinks that would make him go 10 steps back more than help him in his case with his trust. May I ask, is that correct? I just wanted a second opinion, if you don't mind.
Well, what is it that you're actually trying to get clarified?
Debt validation.
I'm sorry, say it a little bit slower.
Debt validation.
Debt validation. So what is it that you're trying to do with debt validation exactly?
He has a child support case, my husband.
I got that.
And I wanted to get it modified. And we're trying, I let him know to go in the courts and get it modified to try to get it cut down. And he's saying it's more detrimental to his case by doing that, it's more detrimental to the case than actually going forward with his whole trust and getting everything together at once. And I wanted a second opinion with it also. I was trying to read your book and go along with your calls, and it's a little hard for me to follow along with you guys. And I'm just trying to figure out exactly how to go along with the case with him to help him.
How long have you been with us now with NTT?
Well, listening along with him, he's been getting me to do it for the last 6 months, almost a year now.
Okay, good. Well, thank you for joining us for all this time. And I want to make sure I have a clear understanding of what it is you're asking. And you're suggesting he go and get an amendment to the existing pending case to get it cut down. That's what you're suggesting.
Yes, sir.
Okay. And he's saying, no, I don't want to go get an amendment because I would rather just do a bill in equity, express trust, and extinguish the debt. Just to make sure I have a clear understanding.
You are correct.
Okay. Do you guys, first of all, does your husband, if he's there, he could come on and talk as well. Does he have anybody?
Good evening, Eric.
Hey, good evening.
Good evening, Eric. This is Lawrence.
Lars. Hey, Lars. Do you have anybody who's you can rely on to teach you about the outlaw side, about what's going on?
Well, I'd rather not do the outlaw way. I'd rather listen to Faith and some of the others on Skype. I know equity is the way to go. It's just once you claim trust, prove trust, gotten trust to what either a black card or either the gold pile on a non-bearing insurance account. What you do with your own LLC after you got it?
But wait a minute, Lars. Let me interrupt you, please. If you don't understand what's going on the outlaw side, if you don't have somebody that can counsel you, then Lars, you will have no idea of all the things that you're waiving when you go into that outlaw court. Because if you don't completely understand how to go straight into equity, then you're going to default in the outlaw court, and that's where the case is right now, and that's where the case is running. So until you understand how to completely remove it from the outlaw court side of the court, for example, in Florida, it's Rule 1070J. I'm pretty sure. Let me look that up. And I would suggest that you find that same rule. Are you familiar with the rules of procedure, civil procedure there in your state?
Yes.
Yes, I am. I take criminal justice myself. For school, I'm going to school for forensic science, so I'm very familiar with the laws of New York State.
Excuse me, it's 1170J in Florida. Well, and you say you're in New York?
I'm in New York, yes.
Yeah, you need to find the rule that matches up to our 1170 here in Florida, 1.170J. You need to find that rule, because until you understand how to remove that action from the outlaw side of the court to get a motion to dismiss it and move it over to equity, you're going to be dealing with two cases concurrently, and the outlaw side can run and hammer you while you're trying to get your case done on the private side for special equity. So in bringing in this question, if you don't understand that these things are going on simultaneously, and if you don't have somebody on the outlaw side who can consult, no matter how much you try and express trust and extinguish the debt, you're still going to get hammered on the outlaw side. So that's why I'm saying you need somebody to consult with on the outlaw side so you really understand what's going on.
That's what I was asking him, the same thing myself, because I said there has to be another side to this, because I couldn't quite understand everything that was being said. Do you have something, a reference, or another person in New York that we could possibly consult with?
I'm sorry, you say that you're a little bit muffled. Say that a little bit slower for me, ma'am.
I apologize. Excuse me for speaking fast. Is there a reference or someone in New York State that we could reference to or speak with that could help us with that?
Well, we can't give legal advice, okay? We're the legal community would have just a terrible fit with that.
Okay.
I have to suggest to you to get Dr. Graves' jurisdictionary, okay? I suggest to you to study and learn your rules of civil procedure.
Okay.
That way, if you decide that you do want to hire an attorney to deal with this situation, when that attorney fails to do what they need to do, because I'll be honest with you, a lot of people need to consult an attorney. That's no doubt about it. We don't condone it, but you know what? Some people need to do that just because they're not competent to deal with their own case. And when the judge says to you, "Are you sure you know what you're doing?" then you better read Section 71 of Henry Gibson's Treatise on Suits and Chancery and know that he's saying to you, are you aware of all the things that you're going to waive if you don't go ahead and object? That's what he's saying. Or if you don't go ahead and express it, are you aware of all the things you might leave on the table or all the things that you might have the right to if you don't properly express it? So that's what the judge is really saying, and there's a lot to know. So, I got to suggest to you, whoever it is that you find that you can properly consult with in your state to give you legal advice that you can confide and know, and they really know what they're doing, that's what I have to suggest for you to do because, yes, extinguishing the debt, putting the doctrine of NTT to task and extinguishing debt is absolutely our ultimate goal. But at the same time, I can't encourage you to do that, going there blind and, walking into a room of hazards. I can't encourage you to do that. I have to encourage you to educate yourself and learn what it is that you're up against. And the past calls, Christian has spoken on many of these things, hypothetically, or with people where he wasn't given legal advice, and there's a lot of good stuff there. And certainly, have you heard of jurisdictionary in the past? Are you familiar with that?
Excuse me, this is Lawrence.
Hey, Lars, are you familiar with jurisdictionary?
I got enough documents. I got 320 gigs of data and 483 PDF books. I got legal documents. I was doing it at law way. I understand what you're saying, and you were telling her correctly if we was going to pursue this at law, and that it's already in the court. No, it's not in the court. They just sent letters of a lien without them being notarized by a judge or, any jurisdiction. If you don't stop them, they can take it out. That's what they're doing. So that's why we're going to stop them. Anyway, the reason for the validation was just to bring the case back into court, just to get something in there, go in for jurisdiction. Once they got to answer jurisdiction, then from there, we got them in our ballpark. And then behind the scenes, we'll be merging the titles, doing UCC 1, UCC 3, getting affidavits, document them, only posting notices. We know this, but you were telling her because she's an at-law-minded. Can you please tell her that? Somebody else with a different knowledge, it ain't going to go her way.
No, actually, I like what you were saying, actually.
Do you remember when he said, don't yoke two separate ox together? Thank you. Anyway, Eric, if you got any advice, great. Sorry to air our troubles, but...
Well, Lars, I have a question. Have you heard of jurisdictionary? Are you familiar?
Yes, I have all the books that Faith and you and all the other people are putting on there. I do have them.
Wait. Do you specifically have jurisdictionary, yes or no? And if
I have a jurisdictionary, yes. I haven't opened it, but it's in my library.
Okay, well,
listen,
it's critical you learn what Dr. Graves teaches if you have it. And if not, get the course before you traverse into the outlaw realm. It's critical. It's foundational, okay?
All right.
And watch his videos, listen to his audios, and read his books, okay? I can't give you any better direction than what Dr. Graves teaches because you can't know equity in its full form until you understand the outlaw side. It's like saying, I know night, but I don't know what day is. But you don't know what night is unless you know what day is. You have to understand both sides of it. And if I were to tell you anything else, I'd be misleading you, and I won't do that.
And I understand. All I was asking is if a person's been in a court for at least 6 times, they got to see how somehow it's being played.
Well,
so
I understand,
I do have a little outlaw.
The other thing I'm going to suggest to you as well, and I'm glad you brought that up about going to court, is not only for your case, but for other cases that are similar, that are of a similar nature to yours, go to court. Now that you have this better understanding about what's going on, and you can see things through the NTT eyes, go and watch how the courts repudiate the trust. And understand that when they do, and the courts are determining the nature of the relationship from the very first moment, and they're going to know what the nature of the relationship is until you go in there and repudiate their imputation of the relation, okay, of them imputing that duty upon you. Until you go in there and repudiate that imputation, they're going to figure that you're a trustee, the one with the liability to pay, and that's why you're paying the child support. So until you understand how to get that court to see a different relation, how to get the court to see it, because you can't just stand up and say it. You got to have the records. You got to have the proof.
Oh, well, yes, the documents we've gotten from them, that's what we're going to use as the title of move and merge. And then we're going to try and get one of them to become the trustee. And if they don't stand up and nobody shows up in court, that's an automatic win. And if she doesn't move over...
Oh, that's not what he's saying. He's saying to learn in trust.
Was that close to the synopsis of it?
Unfortunately, your phone connection is just a little bit hard to make real clear. Make it real clear of what you're saying. It's just maybe a little bit distorted or something. That's why I was getting the lady to speak a little bit slower so I could clearly, distinctly hear what she was saying. I apologize.
Oh, that's surprise. We work on telephones all day long. We talk to people like 12 hours a day, so...
I'm sorry that I'm having a little bit of trouble understanding. Say that one more time to me, Lars, and give it to me a little bit slower, please.
Okay. The theme of the matter was that the documents were sent to me. They're in my hold. I've had them for over 72 hours, unfortunately, without repudiating them. But that's going to be the long run of it. From there, that's what's going to be used to get placed back into, so that we go back into the court. Then we go back into the court, we bring up jurisdiction. Now, we done built up all our NOIs. We're working on them. We have the plans of what's necessary. Anyway, now both things are happening at the same time. Now, it's on the judge, isn't it, to work, or we put a stay on the other case from holding the money from my check, for one thing. But something like that.
Hang on, I'm making a couple notes to ask you a couple questions so I don't forget.
Oh, okay, cool. Do the same.
So you've been given a presentment.
Yep.
All right, so what do you plan on doing with this? First of all, who's the presentment from?
One's from the IRS for frivolous filing, and the other one is from child support. And
wait a second. Okay, one at a time. The one from the IRS, is it does it have a dollar figure attached, or is it just saying don't send us any more frivolous filings?
No, it has a dollar amount that they're actually taking money from a job which I had already given notice to and spoke to their human resources that if anything happened that they was not to do something without notifying me. They didn't notify me, and the money's taken out. And we already know what the Atwell side is of a company following behind money that they aren't sure is supposed to be paid, how they can be held for that too, but moving right along.
It can be held accountable.
Yes,
It is
they can.
illegal document.
Anyway.
I'm listening. I was just
No, I was going to tell her that if they follow behind paying a monetary amount from a third party's direction without checking it, then they could be held at law for in the wrong because it's in one of the laws of this, but it is. But anyway, go ahead.
So we're talking about two different situations here.
Yes, but we wanted to see that we could, in a sense, join of both of them, considering it is one me and then them, and nobody else is there. So,
well, hang on a second, because we're talking about two different situations. There's different ways to handle this. Okay. If you've been listening to the calls for a while,
yes.
the presentment that the IRS has sent you, they probably just basically sent you a letter with a slip at the bottom for you to pay. Correct?
Similar to that, yeah. And they came out with a decree and 6 pages or something at one time, and now they just send that one yearly, like, if you agree to this and keep on, we're just going to do it. I don't want to roll over this year.
Right, okay. Well, the IRS situation, if you remember from many calls in the past where people talked about this, Christian has said for you to take that presentment from the IRS, because that actually is a charged document, and turn that into a special deposit with instructions along with it for them to merge the titles.
That's what I wanted to work on doing.
Okay,
but
that's from the IRS. And the IRS has both the public and the private side. So you can certainly go to some of the past calls, and there's plenty plenty of information. Christian has talked about that on many occasions to do that. Are you familiar with what I'm referencing?
Yes, many of the calls. I listen to only him and maybe Jazz once in a blue moon now. I can't even got time for it.
All right,
so
now we've talked about what to do with the IRS presentment with merging the titles, and that makes that's consistent with what we've talked about over the course of time. You agree, right?
Oh yes, definitely.
Okay.
There's different formats.
All right, that's consistent. So then the other situation you're talking about with the child support court. Now, they've sent you a presentment. Who actually sent you is it the child support court or is it another party?
It's actually the court.
The court sent you the presentment.
Yes.
And is this presentment through a order?
Yes.
Okay. So again, it's a debt title.
Yes.
Have you thought about withdrawing and redepositing and merging the titles on that one? Has that crossed your mind?
Yes.
Okay. And tell me what you've done with that so far. When did you get the presentment, and what was an order from the judge, the presentment?
Well, it was primarily, I've had it for like a week, and right now it's just primarily monetary deductions from my payroll through a company.
But wait, that bill, is that based on an order from the court?
Yes.
All right.
It's about almost an 8-year-old order.
Okay. Do you have the order?
Wasn't able to locate the original. That's why I had asked previously if I was to take the newest document sent and consider that the first, considering that's the last reckoning they gave, and start from there, and anything after that falls underneath it.
Well, so that most recent one's a bill, correct?
Yes.
All right. Well, guess what a bill is?
Check.
No. Oh, yeah, but it's also a debt title.
Yes, it is.
All right. So if it's a debt title, what do we do with NTT with debt titles?
Urge him.
Yes, sir. So, what's your asset title?
Both those documents.
When you say both of those documents, what do you mean?
Yes. What I mean is each one of the bills that they have that are there, and once I take them and present them as a special deposit, then I can move and merge the titles and just send notices to the interested parties post haste, and that's all they see with a covered document for judges' eyes only, and then from there move to get in behind the chamber so he can acknowledge and recognize the trust, hopefully have a bank account also that is underneath the, Christian mentioned how to lock one down so it's actually private again, and then just do banking.
Well, and I appreciate your explaining the scenario, but going back to the debt title, the bill, where is your equity? What's your equitable asset? What is it?
My res documents.
Say again?
My res documents.
What is that?
My res is actually, the res is something. It can be anything.
It's going to be something with your signature on it.
With my signature, actually, when I granted and created and got my power.
So what of those documents, what does the court have what do they have that has your signature on it?
Previous agreements that would have definitely had to have been rescinded. I got a nice power of attorney and rescission document. Well, anyway, but yeah, something to that effect.
They had to create those funds off of something that you gave to that court. Either you signed it or they got your signature by accommodation on. For example, the original indictment.
True.
From 8 years ago.
True.
So they already have the res.
Okay.
That's your asset title. That's your equity.
Now, and just because she's hearing this, aren't there, didn't they take that as a negotiable instrument and make whatever else after it, and that I am in actuality supposed to be entitled to everything and anything that was made after my signature was signed on the document and they took it out the room?
Well, yeah, and you go to the, for example, the chief financial officer for the clerk's office, and that's who's going to have the records of what happened with all those assets or all those things that got created from your signature. But remember, in private trust, in the private, there's no negotiable instrument, just special deposit. But nevertheless, they took that private asset and they sold it on Wall Street and they negotiated it. But then again, because it's a special deposit, you have the right privately to receive all those funds that they created off of it. You have the right. You have the right, because it's a special private relation, to call all those assets, to call everything that got created off of your signature back. And the chief financial officer or the chief accountant or the CFO for the clerk's office will have all those records.
Well, I'm going to do one step better. Hopefully I'll be able, if somebody happens to know how to get the IRS for the individual master file, or what the format or a letter's needed, or a phone number, where a letter can be sent. My Skype is Lawrence at NTT Trust, and that would be the next thing, as Christian say, catch it at the root and just make them give a full final accounting.
But you got to know something, Lars. Is it Lawrence or Lars?
Lawrence.
Lawrence, I apologize. I thought it was Lars. Lawrence, we're still working on that process of catching it at the root. At this point, I need to encourage you to work on it at your local case level, because that's where, at this point, you're going to get your enforcement at, and approaching it doing it through the IRS is a whole other realm that we're not completely familiar with yet. I'm not trying to discourage you, but I'd just rather tell you exactly where we're at with that, instead of encourage you to do something that we're not even so sure about yet. Yes, we've talked about it, and we've talked about it with some firm approaches, but to properly, to really give you the best opportunity for you to be successful, I'm going to suggest you merge titles specifically with your case, okay? And to take those negotiable debt instruments and merge them with your equitable asset and extinguish them, okay? So don't be thinking that you're going to get your signature and you're going to get paid all this money.
No, I ain't looking for nothing like that.
You just have a extinguished debt.
Just extinguish the debt, that's all.
That's it.
And move on. You're right, that's all. Thanks, Eric. Y'all have a good night.
All right. Wait, before you go, just make sure, is it the woman there, I'm sorry, I forget her name.
It is Princess.
Princess, I apologize. Now, did you have anything else you wanted to clarify, or did you get everything clarified in the way you needed to? Because you had some valid concerns.
The call itself, I truly like listening to you guys, and it helps me open up a little bit more. Like I said, do you have a book that I could read for myself? Because I like to research. That's my thing. That I like to look things up myself and just make it that I understand it to me. Would you suggest anything that I can look up that I can study on my behalf?
Absolutely.
Okay.
A Treatise on Suits and Chancery by Henry Gibson. Please ask on the Welcome NTT group, and
I got it.
Or you could just Skype Faith to Trust, and she'll send you the reading list and clue you in. And certainly Gilbert's law summaries on trust. That's it's so well written for so much foundational information to understand how all this stuff works. And then what would be great, Princess, is if you want to read Gilbert's and then come on the call and have some discussions about it, your questions, your foundational questions, because you're new at this, will help teach so many people some of the things that people have been wondering about, because they're kind of reluctant to come on because we're so much far past where we were in terms of where we started. But absolutely, the Gibson's Suits and Chancery and Gilbert's Law Summaries on Trust, there's lots of audios on that stuff. And those two, absolutely.
Okay, perfect. That would be great. Because that's what I really wanted to do. I mean, he lets me listen to his seminars because he downloads MP3s for me, so I can, when I walk to work and when I come home or when I'm on whatever, I can listen to you guys. And it actually is very helpful, but like I told him, I would like to know from the beginning to the end, instead of just picking up where you guys are right now.
And for somebody new coming in, I know that is not so easy.
Yes. And it's a little skeptical in a way, like I told him. And he'd say, okay, he didn't really want me to ask a question too much on the call because I just wanted to make sure that I was asking the right thing. But like I told him, it's not a stupid question as long as you're asking, you're just having a question. It's nothing stupid about it. You're just trying to learn from it.
Yeah, and you're asking questions relevant to his situation, so it's all good. But besides that, based on what you were asking about when you first came on the call, did you have anything else you wanted to ask about or learn?
Just basically just that. I know the laws of New York, so I'm pretty much okay with this basic law, but I'm just trying to learn just the format of how you guys do everything. I'm just pretty much just trying to get into that right now.
Right on. Okay, then. Well, thanks for coming on the call and asking the questions. And Lars, we're on tomorrow night at 10 o'clock if you want to look some of this stuff up and see if you want to ask some questions further tomorrow evening, if it'll give you a chance to step back and come back.
Okay.
Lawrence, excuse me.
Okay, Lawrence. Do you have any other questions?
Yes, no questions, Eric. You have a good evening.
All right, thanks.
Thank you,
guys.
Thank you, everyone.
All right. And you guys, November 7th, 2009 and forward. Star 6, then 1 for anybody else who has any questions or things they want to bring up on the call this evening. Star 6, then 1. Star 6, then 1. Going once, as Christian says. Going twice. Thank you for joining us, everyone, this evening on this Monday, February 21st edition of New Trust Technology, Monday Maxims. I hope everybody got some good things and learned how to once again apply the maxims and how foundational they are. And join us again tomorrow night at 10 p.m. and then Wednesday on TalkShoe and then Saturday at 10 p.m. And we're gonna go ahead and end the call now. So good night, all.